Okay, I'm Eric Schnapper. You prepare a lot the way you prepare in football, in a sense. In the sense that you try to equip yourself as best you can for the things that will happen that you can't foresee. I've identified the things I think will be most important to get across. Bearing in mind that could change. I can recall more than one argument where I walked into the room thinking I was going to focus on one thing, and given the way the court was going, I went and focused on something completely different. And it might have worked, it might not have, but if you see, I remember one case where I saw Justice Alito headed for an argument that I thought was my weaker argument. That's where I went. We won on the original theory that I went with, but you go with what's happening there. So you have your theories about your priorities, that can change, but you have to think that through. You think about what's most important. You think about what kind of argument you can make in a couple of sentences. If an argument takes a page to make, it's no good. It's too cumbersome. You have some arguments that will lead to a lot of more difficult questions. You tend to avoid those. So you try to think out what of the range of 20 or 30 arguments you might have in your brief, which ones you want to use. And maybe that works out, maybe it doesn't. Then I spend a great deal of time thinking about questions. Many come from the other side's brief because many of the court's questions come from that. Other things, you just have to do the best you can to anticipate what's going to come up. As I say, in the notebook I prepare, every question will have its own page. I'll think of as many answers as I can. I'll look up citations. I'll try to find old opinions people wrote. The time to figure out the answer to a question is not when it's being asked. The time to figure out the answer to the question is 4 days before, and you've got half an hour to think it through. So the bulk of my time is spent on that. I will often spend a certain amount of time just memorizing little things, page sites, section numbers, who said what in some previous opinion. I can remember one case where the argument for the other side was weak. There was an amicus brief on their side that was good. It focused on a particular provision, which was it was like 7 digits and 3 subparts. And I decided I'd remember the section number. And the chief asked a question about it, and he didn't remember the section number. He just knew this argument. And I said, yes, that's the issue raised by section 1122B674. And he just gave me the smile, like, you know what's going on here. But it's just, the court's confidence in you as a litigator is greater if you just master those little things. They don't really matter, maybe in some sense, but being able to tell the court, and being able to tell the court where things are in the joint appendix matters. It's very convenient, very effective. And so there's a lot of, sometimes there'll be a lot of memorization of that stuff that goes on. Well, you have to answer the question that's been asked, and the more forthright, the better. If they feel like they haven't really gotten an answer, then they just ask again and again, and it just gets worse. You don't always have to explain your answer. Remember, this may be a question that's not something you want to spend time on. So if asked in a capital case, wasn't it a grisly murder, the best answer is probably yes, but my client's rights were violated, and get out of there. So typically you try to answer briefly in a way that the court will find sufficient, and if there isn't a follow-up question, quickly pivot and talk about the issue that you want to talk about. Or maybe re-answer a question that was asked of the other side that was a topic you want. One of the things that I think people who do this on a regular basis have all learned is that re-answering questions is an incredibly effective tool. The justice who asked it is particularly attentive, and I think the rest of the court feels it shouldn't interrupt that answer because their colleague has asked the question, and he or she is entitled to hear what the response is. And you will see people who've done this on a repeated basis when arguing second or when arguing in reply regularly get up and re-answer questions. And I think it's singularly effective. And what's so nice about it is you get to pick the question you're answering, which you don't get to do when you're being questioned directly. So you could listen through 30 or 40 questions and pick out the question from the justice that's the one you want to talk about, and they'll let you do that and let you give you some time. There was a case I argued a few years ago where, as is often my practice, I went and listened to the argument before, because it just tells you things that are on the court's mind that are a turn of phrase or something. And this was actually the day before, and the Chief Justice asked a question of the other side, which is actually, in light of what I said, you can understand why it was so important. He said, "Why is your standard better than the other side's standard?" And I remember sitting there thinking, oh, gosh, I wish he'd asked me that question. And I mulled it over overnight. I came in at the appropriate point. I got up and I said, I'd like to answer the question that was asked by the Chief Justice yesterday morning of counsel for respondent in the Lozman case. And the Chief Justice just smiled at me and he said, "I don't remember that question." And I reminded him what the question was and re-answered it. But it's the sort of thing the court, I think, really appreciates. And so you can't prepare for that, but it's very important in oral argument when it's available. Clearly, the nature of the conversation is you've got 9 justices. They typically haven't discussed this before amongst themselves. They come in there. They're trying to make a point to one another, but they can't say, "Thank you, counsel, hold on a second. Justice Scalia, what about this?" They can't do that. So if they want to make a point, they make it through a question to you. And if it might be a difficult question because they're not on your side, or it might be a helpful question, we refer to them as a softball question, because they're trying to be helpful. But there's a certain amount of that goes on, but the hard questions are still the hard questions. Whether they're motivated by an attempt to persuade the other justices doesn't really affect things. You occasionally get an easy question. I seem unable to recall too many of those, and they're helpful to let you get back to some point you want to make. But you don't. I'm not remembering anything. Not only because the harder ones are more painful and they're more vivid. I just don't remember a lot of those. I think sometimes you see those because a lawyer is just getting in trouble, and the justice on their side, or acting simply out of compassion, asks them a question that gets them out of a hole. But it's the vast majority of questions are not like that. So typically, I think the pattern is that the largest percentage of questions of any particular lawyer will come from the justices inclined to be on the other side. And so I think that pattern holds up pretty consistently. So if I get a hostile question from a tough question from Justice Ginsburg, that's a bad sign. If the other side gets a tough question from Justice Scalia, that's a good sign for me. I think when you're in the middle of an oral argument, you don't have much time to think about such things. You're just trying to deal with the questions as best you can. It'd be like if you're in battle and someone's shooting at you from 3 different sides. Do you worry about whether they're tall or short? The answer is no. You try to duck and not get hit. And the pattern of the questions don't correlate all that much with something anyone would have said before. The issues are new. They haven't thought them through before, typically. I don't know that I can recall anything that would amount to responding to people's personality. You might have a situation in which someone had written something about a particular issue that you'd want to point to something they'd said in an opinion. There was a case, I argued a case earlier this year about the things worn by people in steel mills. I was exceptionally well prepared to talk about the steel mill where the Chief Justice had worked in high school. I knew about that. That was special for him, never came up. That was an unusual situation where I knew something specific to a justice. It's almost never an issue. Now, maybe in con law where you're seeing recurring issues about freedom of speech or searches or whatever, and justices have particular interests and concerns and priorities. But the cases I typically work on, the issues are really quite distinct from things that court's done before. And you might, in sort of general terms, anticipate more support from one group of justices than from another. But beyond that, I don't see anything that's different. I think I'd be more likely to give a joking answer to a question from Scalia than maybe from somebody else, because he's got a sense of humor. But you, of course, have to be careful about that sort of thing. I give you an example of that. In a case I was arguing, one of I lost, unfortunately, had to do with the meaning of the word close, and I had gotten a series of questions about whether something just looks like close, and I was arguing, well, you have to know more than just what it looks like, and I'd given some practical examples of, my favorite one was an airbag vest that people wear on horses. If they fall off the horse, it blows up and keeps them from being injured. Looks like a vest. If you knew what it was, you wouldn't call it close. So I was trying to make that argument, and Justice Scalia was after me about it. And so then I did the following, which I would not have done with at least most members of the court. I said, you know, the parable about something that looks like a duck and quacks like a duck. And he said, yes, of course. If it looks like a duck, it quacks like a duck, it's a duck. I said, right, but if it looks like a duck and it quacks like a duck, but it's just sort of sitting there, and there's a shed nearby with a bunch of people in camouflage gear with guns, it's not a duck. You have to have all the information. Now, I would not do that with every member of the court. But it was worked fine. I mean, we still lost. But on the whole, no. There are, I think, for academics, these things loom large. People write long articles and get tenure and chairs and professorships over this sort of thing. I don't find helpful as a litigator. But if you had a case about a search and seizure and what was reasonable cause or an emergency or something like that, you could have a situation where one or any number of members of the court had written about that. Or if you had something about the line between what abortions are protected and not protected, and everyone in the court had written about that, then you could use that sort of thing. And you would argue, there'd be some arguments that would be more relevant to some justices than others. Now, again, you don't have that much control over your airtime, but certainly you could get a question from Justice Kennedy about something he'd written about, and then you could point to that or at least focus on that. But the issues that I work on typically are simply too distinct one from the other for that to happen.